I sat down with Jason Allan from Allan Law in Aurora to talk about a number of estate planning topics. And one of the topics we talked about is parents helping their kids with the purchase of a new home. This is a very common situation. Parents, adult parents, want to help their children with the purchase of a home. And we talk about some of the legal and estate planning considerations for parents who want to advance either a gift or a loan to their adult children, and just some things they should think about as they're entering into that kind of an arrangement within their family. So hopefully you find this video helpful, and I'll turn it over to my discussion with Jason Allan.
Maybe we could switch gears and talk about another use case that's come up a lot over the past couple of years. And that is parents who want to either gift or loan money to their kids to help them with the purchase of a house. And that has come across my desk in a couple forms. So one is like an outright gift of money, right, for a down payment to a child and their spouse. And then the second scenario is, a loan where they say, okay, we'll give you this money, but it's designed to be a loan that's paid back over a period of time. Those are the two scenarios that I see come up again and again. And so maybe talk to somebody who's considering doing that and the things that they should think about before they enter into that kind of arrangement.
Yeah, that's an area that's rife with different types of litigation, family law litigation in particular, or disputes.
Mm-hmm.
And so I think there's things to keep in mind, whether it's a gift or a loan. So
Mm-hmm.
if it's a loan, the loan should be documented.
Mm-hmm.
Both the parent and the child should have a promissory note or a loan agreement,
Mm-hmm.
confirming the money advanced is in fact a loan and not a gift.
Mm-hmm.
And the agreement should address the terms for repayment.
Mm-hmm.
When is the money due?
Yep.
And what are the terms associated with that?
Mm-hmm.
In family law, if the advancement of funds hasn't been documented at contemporaneous with the time of the money being transferred as a loan, then it'll be treated as a gift. And why that's important is if the money is being invested in a family home. In Ontario, that's called a matrimonial home, which is the home property that you're using with your spouse. And you can have more than one matrimonial home, by the way. So you can have a house, it's your principal residence, and you can have a vacation home, and they can both be matrimonial homes. So if the money being advanced by the parent to the child is being invested into a matrimonial home, well, under the family law rules, gifts are not shared with the spouse, the exception being if the gift is in a matrimonial home. So if you get money from your parents and you use the money to pay off your mortgage or to buy a house that you're using with a spouse, if that is a gift, it's not shared with the spouse. Sorry, if it's a gift, the spouse shares in the money. So if the intention is, and often how this arises is, of course, the couple who receive the money will separate, and then the child whose parents advance the money will claim that money is owing to mom and dad, or maybe mom and dad claim the money is owing. And the purpose for that is to be able to try to get the money back, or to discount the what we call net family property of the spouse who received the money. Well, the judges are pretty hard on people who claim the money advanced was a loan after the fact, because if there's no written agreement to show the money was loaned at the time the money was advanced, and not 10 years later when the couple separates, then chances are the judge will treat the money advanced as a gift, which means if the money's been invested into a home, it'll end up being shared with the spouse. And so that's important. The parent may also want to consider, if the money is in fact being loaned, having some kind of security for the loan, like a registered mortgage on title. And it can be without interest, but if there's security on title, all the more evidence to show that money being advanced was a true loan.
Yeah.
The more the money looks like a real loan and less like a interfamily gift.
Yes.
The more probable it is that the money will in fact be able to be excluded from the division of assets and repaid to the parents in the event of a separation, right? So I think that's important to have documentation to show that the money's owing. And of course, the parents may have a will that leaves everything equally to their children. And the question will be whether the money that advanced was owing to mom and dad and needs to be repaid. So that can be a question between siblings who can fight over that. And if there's a proper loan agreement in place, then it's clear that that's money is owing. So it avoids not only matrimonial problems for the child who's receiving the money, but it also avoids intra-family disputes between siblings who may be arguing over whether their sibling owes that money back to mom and dad. If the money is intended to be a gift, well, the parents should be aware of the implications of the gift being invested in the home, as I've already gone over, which basically means they're gifting the money to the child's spouse as well. The intention is not to have the spouse of the child receiving the money share in it. Then the spouses can do a domestic agreement with each other. They can agree that the money which was received by the one spouse and invested into the home will be repaid to that spouse and will not be part of any division of assets. So that's an important consideration. Sorry, if it's a gift to the child, also making that clear. It doesn't hurt to make that clear in documentation, so that if the parents die, the other children understand that money is or is not owing back. Those are all some important things to keep in mind.
And so let's say that somebody wants to do this for their child, either a loan or a gift. And we've said, hey, they need to create a contract. What's the process with the lawyer? Like, is that an onerous process? Is it a fairly simple process to come in and have, an agreement drafted? Maybe talk people through what that looks like.
Well, if it's an agreement between spouses, there has to be proper financial disclosure, because there's been lots of cases where people sign domestic agreements and then try to get out of them. And the courts have made it very clear that these agreements require financial disclosure. So that's one thing to keep in mind. If it's an agreement between the parents and the child, say confirming that the money is a loan, that can be a straightforward type of agreement. The things to think about would be when the money is owing, if it's a loan, right? Because the parents have to be aware of things like limitation periods, right? There are deadlines in our legal system for how much time you have available to bring a claim, to enforce the repayment of the money. Was there interest being charged? When is the money due? What are the terms associated with the advancement of the funds? So the documents can be prepared, but there are some considerations to go through when thinking about what the terms are.
And that's the type of thing where you'd encourage somebody to reach out to a lawyer to help you with that. Like if someone's made that decision, it's, hey, you can maybe sketch out at a high level what you want the expectations to be between you and your child. Is it a loan? Is it a gift? If it's a loan, over what period of time do we want to have it repaid? Maybe it's a loan that eventually turns into a gift, right? Once people have kind of made those decisions at maybe the high level, is at the point at which you'd say, hey, speak to a lawyer, right? Like you don't want people doing this stuff on their own, kind of at their kitchen table, and then have those documents not stand up down the road, right?
Well, I think it's better that they do it. So if they're going to do it on their own, that's better than not doing it.
Right.
Like any type of contract, you can enter into your own contracts without the benefit of legal advice, or you prepare your own contracts.
Yeah.
You're allowed to do that. Okay. Doesn't necessarily mean that the agreement is not valid if it was prepared without a lawyer. But like anything else, especially if it's a significant amount of money, I don't think it hurts to have a lawyer involved, either to prepare the agreement or to give you legal advice about it if you're on the receiving end of the agreement. I think it's a good idea to have a lawyer involved, but that's not to say that that's necessarily required to make it legal.
Okay. So you can build an agreement on your own that will stand up, but I guess maybe it's sort of, step carefully. And if you feel like it might be in an amount or, of a magnitude that it would really change your life, or it would change the lives of your the people you leave behind, maybe don't chance it and have a discussion with a professional before you go down that path?
I think it's worth having a lawyer involved,
Mm-hmm.
but I make it clear that you're able to do your own contracts. But I
Yeah.
think, like anything else, you're better off having someone who is well versed in the language that's necessary to properly draft the agreement. Other types of considerations you may have kept in mind. There may be things the lawyer brings to your attention which you never considered, which are important.
Mm-hmm.
So I certainly don't want to diminish the importance of having a lawyer involved.
Yeah.
But if the choice is not having an agreement or having it prepared by a lawyer, I would encourage people to have the agreement properly documented in any event. But certainly, I think there's a benefit to having a professional involved to review what you've done on your own, but probably better to have it prepared by a lawyer who can properly set everything out. And the other party may require even independent legal advice.
Mm-hmm.